Well, good afternoon, everybody. Good afternoon to those of you who are watching live on Facebook. I'm Rachel Mitchell. I'm the Maricopa County Attorney. I want to start off today by talking about something that has come up in speaking to different members of the press, as a report back not only to the media but also to the public that we serve. When I took over the office, there was a large backlog of cases, and that was a priority for me to get through those. And of course, we had a staffing shortage, so it was also important that I make sure that we had the staff in place to address those issues. So let me report back the numbers as of the end of May. So in May of 2022, excluding juvenile cases and misdemeanors, we had 9,215 felony submittals pending review. As of May of this year, that has been reduced just shy of 57% to 3,976. As many of you are aware, there were some issues surrounding statutes of limitations regarding misdemeanor offenses under the previous administration. That also has been a priority for me. In May of 2022, we had 1,187 misdemeanor submittals pending review. We have reduced that by 55.5% down to 528. In addition, because of the statute of limitations issue, we began tracking submittals that were pending review older than 6 months. And as of May 2023, in terms of misdemeanor submittals, which have typically a 1-year statute of limitations, we have 0 submittals pending over 6 months. So in total, we have reduced our backlog 57.2%. We're still working on it. We want to keep going on that. And just to give you all a perspective of how many cases this office handles, last year, the number of submittals that came into our office for review, and this includes felonies, misdemeanors, and juvenile cases, is 55,775. And with that, I'll take your questions. Matt?
Can you talk about the,
sorry.
Sorry. Go ahead. The Mitchum case appeal. Can you give us any updates on that? Where is that?
Yes, the Mitchum case was argued this morning in front of the Court of Appeals, and so we are awaiting a decision on that from the Court of Appeals, and I don't have a timeline to give you. You'd have to ask them.
Sure. And one other question before you go. On the policy 7.3, where is that at as far as plea deals? The question is brought up because of Charles Ryan's case.
So 7.3 was a policy that it controls some of the things that we look at in terms of weapons. We amended that back in September under my administration. But in regards to Charles Ryan, and I have a feeling Mr. Casey is also here to ask those questions regarding that case. Let me just say this. This is a pending case in front of my office, and I cannot speak specifically to it. We give all defendants the courtesy, and it's really an ethical requirement of not talking about their cases prior to resolution. That said, when this case is resolved, however it is resolved, I am more than happy to talk to you in detail as to the thought process throughout this case, how decisions were made by me, and but I can't do that until this case is settled.
Can you talk beyond 7.1, the order that you were mentioning? Can you talk about some of the factors that go into deciding whether or not to extend a plea agreement offer to a defendant?
So the reality is we extend plea offers in a large percentage of cases. It's a necessity based on volume. As you heard, 55,000 cases come into this office in a year. We look at the whole thing. One of the things that I have made my administration based on is the fact that I don't believe in painting people with a broad brush, that we look at not only the charges, but also the person, their history, what was behind this offense, their future dangerousness, treatability, et cetera. So there's a whole host of facts. We also look at the strength of the case. We talk to victims. So we try to do a very, very thorough consideration. And in any case involving a high-profile nature charge or person, oftentimes I will seek the advice of my senior leadership in this office, but I will emphasize that the final decision rests with me.
How common is it to call an affiant in a search warrant to testify before a grand jury?
I'll give you the lawyerly answer. It depends. It depends on what their role is in the case. A lot of times the case agent is the affiant in the search warrant. And so in those situations, I would call him. But sometimes that's not the case agent. So it just really depends if they're the primary person responsible for the overall investigation as to whether I would call that person.
Thank you.
Okay. Dennis.
I have a follow-up on Matt Casey's questions. I read his story today, and there was a attorney quoted in that saying it's a two-tier justice system. With people looking at the situation with Chuck Ryan case, why wouldn't they think there's a two-tier justice system? Mr. Ryan has already avoided aggravated assault against a police officer. I think a lot of people read that and say, look, if I was out waving a gun at a cop, how could I avoid that indictment? And now there's a plea deal that may or may not include an opportunity for him to, avoid any time in a prison cell. Maybe you can speak to that.
Well, again, not talking about any sort of resolution in this case. What I can tell you is that every defendant in this case gets the same consideration in terms of we look at a case for what we have a reasonable likelihood of conviction on, and that includes what charges we file. But then we look at the totality of the facts of the case. And, in a situation such as this, be assured that I've read the police reports personally. I've reviewed the body cams personally. And I have sought the advice of others, but again, it is my decision. And I'm happy to talk about that once this case is sentenced.
Can you talk about how he avoided the aggravated assault against a police officer charge? Because again, a lot of people in this room pointing a gun at a cop, that's serious business. I know he's in the Department of Corrections, she's the former guy, and he served the state for a long time, and that is a consideration, but he is pointing a gun at police officers.
I looked at all of it. I felt that this charge that was filed, these charges that were filed against him were the appropriate charges. But that said, I'm not going to go beyond that because I want to wait till this case is disposed.
And you said you treat everybody equally. How many times, in similar situations like this, could somebody avoid that kind of a serious charge against police officers? Is this common that if you go waving a gun around at cops that you avoid the aggravated assault charge? Is this common?
It's a case-specific situation. I've had other cases that I've looked at where, we're looking at a variety of factors involved in it, whether there's a reasonable likelihood of conviction. So I'm not going to give Mr. Ryan, I've never met Mr. Ryan, I'm not going to give him any sort of consideration that I would not give anybody else that is a member of this community. Yes, ma'am.
Talking about the Essa Williams case, question from 12 News here. We'd like to know why the body camera in the Williams case, who is the suspect believed to have shot Officer Tyler Moldovan, why is that sealed?
Oftentimes when a case is still pending, the attorney who is involved in the case, or even sometimes it's the other side, will ask that it be sealed. There can be a number of reasons for that. It could be so that there's not a tainting of the jury pool. It could be because there may be some additional information that they need to glean before releasing that. So it could be a number of reasons.
Okay, so Phoenix Police is saying that there's a court order blocking the release of the video connected to the Tyler Moldovan shooting. Are you aware of this court order, and do you support the blocking of the release of this video?
I will talk to the attorney. I can talk to the attorneys and ask them why they did it. I can certainly, from what I've seen, I've watched the video, and I'm very familiar with the case. In fact, it occurred before I was county attorney, and I responded to the scene. So I can certainly understand some of the reasons for it. Obviously, it's a horrific situation, and I've been following it. I am thrilled to see that Officer Moldovan is recovering like he has. That's wonderful. So.
Any other questions? Yes.
Okay.
The U.S. Attorney's Office released yesterday 3 people have pleaded guilty to giving a gun to Officer Tyler Moldovan's accused shooter. None of those guns were the ones believed that were used in the shooting with the officer. We know from initial court paperwork and paperwork in the U.S. Attorney's case, a 4th gun was found at the scene. Is NCAO prosecuting how Essa Williams got the gun, or is there any facing charges for providing that gun in some way to Williams?
Right now, the charges that are pending related to that case in my office are the original charges that were filed against Mr. Williams, and that is aggravated assault of a police officer, attempted first-degree murder, aggravated assault of a Class 3, which is different than count 1, and then 3 counts of misconduct involving weapons. So those were all from the original situation. And ethics require me to say appropriately, charges are not convictions, and people are innocent until proven guilty by my office. But that is the only case we have in front of us. I know that the U.S. Attorney's Office took on the responsibility of handling the other gun-related crimes that are tangentially related to this, and I think it shows a great interagency cooperation. But that's what's pending in front of us right now.
Okay. So a prohibited possessor usually can't have a gun due to past record. So do penalties need to be harsher to ensure guns don't get into the wrong hands?
You know, that's a topic I've been talking about for a few months now, is the misconduct involving weapons charge, which is most of the time relates to a person who has a felony conviction, who is possessing a firearm. And while the penalties are there, so my focus is not on that, but one of the things that I do think there needs to be is better cooperation from other states, because one of the things that I as a prosecutor have to prove is that this person who had this gun also had a prior felony conviction. If it's from Arizona, we keep really sufficient records here. But some other states, it's difficult when they move here from another state, the felony is in the other state, to obtain those records and for those records to be adequate for us to prove that this person here was that person there. And so my office is undergoing some efforts to bolster those cases to make them stronger, as well as to work on some things that can affect other states' record keeping. But that said, these are very serious offenses, and we are seeing a correlation between felons in possessions of guns and subsequent violent crime. Like, honestly, I've never seen in my 30 years of prosecution. So it is definitely a harbinger of things to come. Yes, ma'am.
Hi. So I'm not sure if you're aware of, there was a missing persons case, Lucy Castro, a woman who was released from Maricopa County Sheriff's Office, though she had a mental health petition pending, and the family has said that they feel that the justice system has let them down, and there isn't adequate communication between law enforcement and the mental health system. Do you have a comment on that?
I believe that situation involved other agencies besides Maricopa County Attorney's Office, so I can't really speak to that specifically. I would refer you to those agencies. But that said, obviously there is certainly a frequent interaction that we see between mental health system and law enforcement or the criminal justice system that is, important. Dennis.
Okay, one more.
Okay.
I feel like I gotta ask a political question.
Okay.
I spoke with Paul Charlton yesterday, he's former U.S. Attorney for Arizona, and he said he is worried about some of the rhetoric being put forth and put out there by supporters of Donald Trump. You've got Congressman Andy Biggs saying we've entered a war phase. You've got Carrie Lake saying that anybody who wants to go after Trump has to go through, card-carrying members of the National Rifle Association. So Charlton says he's worried that, that sends a wrong message, that people could interpret that as an invitation to violence, that it could turn their anger into some sort of action. As you see all this play out and you see this rhetoric out there, are you at all concerned? And do you think that this is appropriate kind of language coming from these types of leaders?
You know, I love this country, and I love this country because we have the rule of law. And that means that if we want a law change, there's a process to do that. If we want a politician change, there's a process to do that. And what I would say is when I hear things, and I'm not specifically speaking to any particular statements because I didn't hear the whole context, but when I hear things about bypassing that, that is not comforting to me because I love our system and I believe in our system. And so what I would say to individuals who are listening out there is, having worked in government for 30 years, the people are good people. And they're trying to be public servants and to follow the law. Not everybody's perfect. There's no profession where everybody's perfect. I hear tell even the media, although nobody has proven that to me yet. But people need to rely on the system, trust the people who are working this system, and to understand that there is a process. And when we get away from the process, when we get away from the rule of law, then we become the rule of man. And that is something that we've seen fail time and time again in terms of personal liberty in other countries. And so I would urge people to keep that in mind. Yes, ma'am.
What is your office seeing in terms of teenagers and gun-related charges? Are there any trends? How do you make decisions on prosecuting those cases? If a teen is under 18, should the parent, guardian also be held responsible?
Okay. Make sure I answer all of those. We are seeing an upward trend of violence in this country. We have been for several years now. And that trend, unfortunately, has now filtered down to our kids. And that includes teenagers, of course. I was briefed on this just recently by my juvenile attorneys and leadership there, and we are definitely seeing an uptick in it. It really concerns me because we need to have an appropriate response at that level, and we're willing to work with the courts to make sure we do that. Because once that trigger is pulled, or once that person gets close to 18 or becomes 18, it's a very different story that I don't want to see happen to our kids. And so I think we, as a society, really need to take a careful look at that. As far as parents, it's again, it's a very case-specific kind of thing. You have to look at what they knew, if they received any warnings, et cetera. And we're going to look at that if any cases are submitted to us. So it's not off the table, but we're going to look at each individual set of facts.
There's a case with Stephen Jacobo. I'm not sure if you're familiar with it.
I am.
The family, they said that it's been taking about 7 months to bring up the charges against their son's killer. Why was this case has just taken so long, or where can the family expect any action coming in?
So that case happened in November of last year, and it was submitted to us shortly after that. We did further it back to the police agency to do some additional investigation. It came back in January. We still felt like additional investigation needed to be done. And it was resubmitted to our office then as of this morning. We got it. And so while I certainly understand just the anguish that Stephen's parents are going through right now, wanting to see justice for their son, what I would say is this: as an experienced trial attorney, you don't want to put speed over accuracy or thoroughness, and we want to get it right. We want to get it right the first time because we only have a first time, and that's what we're doing.
Thank you so much. The Phoenix Police Department announced a plan to reduce crime by 5%. I was just wondering what role the county attorney's office have in that plan. Do you have enough staff to handle the influx of arrests?
Yeah, I think it was with your news station, I used a sports analogy the other day, which was that, the police and God bless them, we need them. They can run it up to the 1 yard line, but you have to have a prosecutor to take it into the goal, the end zone. And yes, we do have the staff to do that. We are in communication with the police department about their efforts, and we're working collaboratively. We communicate so that we can ensure the investigations are what we need for success. And then also we're staffing the initial appearance court 24 hours a day, 7 days a week, to make sure that appropriate bonds are asked for so that those who are dangerous to society are kept in. Okay. Okay, thank you.